Deputy Attorney General Rod Rosenstein was the keynote speaker at a meeting of lawyers for civil justice. He talked about corporations and the rule of law. This is 25 Minutes.
Thank you. Well, we are extremely honored tonight to have the Deputy Attorney General of the United States of America, Mr. Rod Rosenstein, here with us tonight, and it is my distinct pleasure and honor to offer this introduction. I had the pleasure of meeting Attorney General Rosenstein last week at the IADC Corporate Counsel College for a few minutes, and it was a pleasure, and it was even more of a pleasure to have dinner tonight, so thank you. Rod Rosenstein was sworn in as the 37th Deputy Attorney General of the United States on April 26, 2017 by Attorney General Jeff Sessions. Mr. Rosenstein graduated from the Wharton School of the University of Pennsylvania with a BS in Economics, summa cum laude, in 1986. He earned his JD cum laude in 1989 from Harvard Law School, where he was an editor of the Harvard Law Review. Upon graduation, he served as a law clerk to Judge Douglas Ginsburg of the United States Court of Appeals for the District of Columbia. After joining the United States Department of Justice through the Attorney General's Honors Program in 1990, Mr. Rosenstein prosecuted public corruption cases as a trial lawyer with the Public Integrity Section of the Criminal Division. He then served as counsel to the Deputy Attorney General from 1993 and 94, Special Assistant to the Criminal Division's Assistant Attorney General, 94 and 95, and Associate Independent Counsel, 95 to 97. In 1997, Mr. Rosenstein became an Assistant U.S. Attorney in Maryland. He prosecuted cases in the United States District Court and briefed and argued appeals in the U.S. Court of Appeals for the Fourth Circuit. He also coordinated the credit card fraud and international assistance programs. From 2001 to 2005, Mr. Rosenstein served as Principal Deputy Assistant Attorney General for the Tax Division of the United States Department of Justice. He supervised the division's criminal sections and coordinated the tax enforcement activities of the Tax Division, the United States Attorney's offices, and the Internal Revenue Service. He also oversaw civil litigation and served as the acting head of the Tax Division when the Assistant Attorney General was unavailable, and he personally briefed and argued federal civil appeals. Mr. Rosenstein served as the United States Attorney for the District of Maryland from 2005 to 2017. He oversaw federal criminal and civil litigation and developed and implemented federal law enforcement strategies in Maryland. During his tenure as U.S. Attorney, Mr. Rosenstein served as the Washington-Baltimore High-Intensity Drug Trafficking Area Task Force and on the Attorney General's Advisory Committee. He also personally litigated cases in the United States District Court and the United States Court of Appeals for the Fourth Circuit. So, the only thing Mr. Rosenstein did not do is, during his time at Harvard, he did not become a fan of the Red Sox, the Patriots, the Bruins, or the Celtics. Because he was too busy. So, despite that, it is my honor to welcome our distinguished guest, Deputy Attorney General Rod Rosenstein.
Well, thank you, Jim, for that kind introduction. I enjoyed meeting you and several of your colleagues in Chicago last week, and thank you for coming to my neighborhood for dinner tonight. Jim, I admire your commitment to the cause of justice. I'm also grateful to Molly Craig, the chairperson for this event, and to Andrea Looney and the staff of the Lawyers for Civil Justice. Your organization works to promote fairness in the civil justice system because your members rely on the rule of law. This is a fitting time to discuss the rule of law because May 1st was Law Day in the United States. President Trump issued a Law Day proclamation on Tuesday, as he did 1 year ago. The president explained that our founders risked their lives, fortunes, and sacred honor in defense of the values of liberty, justice, and equality. They protected those values with a constitution that established a government of limited and separated powers that enables the rule of law to prevail over the whims of government officials. As President Trump said in his proclamation, our Constitution vests the power to create laws in the Congress, the power to execute laws in the President, and the power to interpret laws in an independent judiciary. The separation of powers is a structural safeguard that divides power horizontally within our federal government. The President's proclamation quoted the great Supreme Court Justice Antonin Scalia, who frequently observed that the rule of law is not just about words on paper. In order to preserve our republic, each branch must take care to fulfill its duties without infringing the rights of the people or the responsibilities of the other branches. Our system of government is not self-executing. It relies on wisdom and self-restraint. In a democratic republic, liberty is protected by cultural norms as well as constitutional text. Lawyers and judges bear great responsibility for implementing and explaining those principles. The farther we get from the founding generation, the less we appreciate how much everything depends on the people and not just the words on paper. Abraham Lincoln believed that the best way to ensure the survival of what he called our edifice of liberty and equal rights is to enshrine reverence for the rule of law in the hearts of the citizens. Let reverence for the laws, he implored, be breathed by every American mother. Let it be taught in schools, in seminaries, and in colleges. Let it be written in primers, spelling books, and in almanacs. Let it be preached from the pulpit, proclaimed in legislative halls, and enforced in courts of justice. And, Lincoln concluded, let it become the political religion of the nation, and let the old and the young, the rich and the poor, the grave and the gay, of all sexes and tongues and colors and conditions, let them all keep the rule of law. When that ethos prevails throughout the nation, Lincoln said, efforts to subvert liberty will be fruitless and vain. In Shakespeare's play about Henry VI, the character Dick the Butcher has an observation about lawyers. Many of you know it. He famously proclaims, the first thing we do, let's kill all the lawyers. Now, that remark is often misinterpreted. Dick the Butcher is not a businessman upset about the surfeit of lawyers or the burden of overregulation. He is a criminal, a villain scheming to take over the government. Now, Shakespeare's point is that without lawyers, nobody would need to follow the law. Now, that would be good for criminals like Dick, but it would be bad for honest people, and it would be very bad for business. The rule of law is essential to commerce. It allows businesses to enter contracts, make investments, and project revenue with some assurance about the future. It establishes a mechanism to resolve disputes, enforce contracts, and punish fraud, and it provides a degree of protection from arbitrary actions by government officials. The American Revolution of 1776 was not just a political revolution, it was also an economic revolution. The movement included mercantilists, farmers, shopkeepers, and other ordinary men and women who banded together essentially to protest excessive regulation. The colonists were upset about burdensome taxes, they were upset about restrictions on their ability to develop the western frontier, and they were concerned about unfair trade practices. Now, today, President Trump is mindful about the importance of promoting innovation and avoiding unnecessary interference in law-abiding enterprises. And under the leadership of Attorney General Jeff Sessions, our Department of Justice is doing its part to promote an environment where businesses can thrive. The Department of Justice, of course, is not a business, and its mission differs in key respects. But many of the issues that we confront are familiar to anybody who works in a large organization. We strategize about how to improve efficiency while meeting our constituents' needs. We focus on recruiting and retaining the best and brightest people, training them and measuring their progress. We constantly strive to do better, to better manage our budget, and to do more with less. One of our most important duties is to safeguard our brand, to protect the integrity of the Department of Justice. We do that by enforcing high standards, defending our people when they're in the right, and taking appropriate action when they're not. And we continually adapt to face new challenges. But as we pursue new goals and policies, we are guided by timeless principles. And the most significant principle is our duty to promote a justice system founded on the rule of law. Your organization also helps to advance the rule of law through its efforts to achieve fairness and consistency in the justice system and to reduce the costs and burdens of litigation. You seek to streamline complex rules of procedure, and you advocate for greater transparency and predictability where existing policies are outdated or inefficient. At the Department of Justice, our attorneys face similar challenges. They must identify and apply an array of policies and guidelines articulated in countless memos and manuals. Memos can be useful in explaining department policies and initiatives, but they bring several drawbacks. One problem is that it became difficult for prosecutors to keep track of all the memos that were issued from headquarters in Washington. So we are working to consolidate all appropriate department guidance into one central manual that will provide clear guidance for our employees around the country. The United States Attorney's Manual, as it is currently called, was designed to be a quick and ready reference. It would reflect internal department policies and procedures for our 115,000 employees. It's also a public resource, which increases the department's transparency and accountability because it tells people what our rules are. Now, the manual does not create a private right of action. I want to emphasize that point for those of you in the private sector. You can't use it against us in individual cases. It's also not meant to be an exhaustive list of constitutional rights, laws, regulations, or general legal principles, but it promotes consistency and proportionality and predictability in law enforcement. And that, in turn, enhances public confidence in the justice system. Now, as part of the effort to consolidate and streamline our policies, we ordered a comprehensive review and an update to the manual for the first time in at least 20 years. We're reviewing the entire manual, a total of approximately 11,000 pages. We're identifying redundancies, clarifying ambiguities, eliminating surplusage, and incorporating constructive additions. I hope these efforts will encourage current and future department leaders to write fewer memos and instead to put policy changes directly into the manual. Many of my predecessors are known for the memos they wrote at the department, the Thompson memo, the Yates memo, the Phillip memo. I committed when I took this job there would be no Rosenstein memo. And I'm going to do my best to adhere to that. Now, our manual helps to guide us. It helps to guide the exercise of prosecutorial discretion, and that is important because the rule of law is about applying neutral principles and basing our decisions on the truth. The defense attorneys understand that concept very well. The job may involve representing an unpopular cause. It's not always easy, but it is essential to safeguarding liberty. Consider the Boston Massacre. In 1770, 5 colonists died after British soldiers fired on a crowd. The British captain and 8 soldiers were charged in a court in America. They were charged with murder. Now, most lawyers were unwilling to represent the soldiers, but future President John Adams agreed to do so. Adams was just a humble private attorney at the time. His political position was firmly on the side of the victim colonists. He agreed that the British troops should have withdrawn rather than firing on the crowd. But Adams felt obligated to defend the rule of law. He said that he had no hesitation in answering that counsel ought to be the very last thing that an accused person should want for in a free country. This is before the Constitution. They were operating under British law at the time, but Adams felt very strongly about that principle. Adams went on to secure the acquittal of the British captain. He later represented 8 other British soldiers. 6 of them were acquitted. 2 were convicted of manslaughter, but received only minor punishments. During his argument for the defense, Adams famously observed that facts are stubborn things. And whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of the facts and the evidence. Defending British soldiers who killed American colonists was not a popular cause. And America in 1770 was a very different place from what it is today. Adams did not merely face criticism. He confronted a real fear, in his own words, of infamy or even death. In a diary entry about the trial, Adams wrote as follows: "In the evening, I expressed to Mrs. Adams all my apprehensions. That excellent lady who has always encouraged me burst into tears, but said that she was very sensible of all the danger to her and to our children, as well as to me, but she thought I had done as I ought. She was very willing to share in all that was to come and place her trust in Providence." Adams wrote that the experience procured in me anxiety and obloquy. It was, however, one of the most gallant, generous, manly, and disinterested actions of my whole life, and one of the best pieces of service I ever rendered my country. When the stakes are high, some people are tempted to dispense with the rules and pursue an expedient result. But Adams set America on a different course. He chose to stand for the rule of law, even in challenging circumstances. All lawyers share an interest in making sure that our legal system respects due process and pursues the truth. An adversarial system does not require opposing lawyers to be enemies. As a prosecutor, I always appreciated a strong defense counsel on the other side. A good defense attorney forces prosecutors to make better arguments, marshal stronger evidence, and refine their reasoning. The book of Proverbs says that iron sharpens iron, and so one person sharpens another. Respectful debate can help us clarify our understanding, reveal facts, and achieve a just result. And speaking of just results, I'm going to discuss a few of the legal risks that your companies and corporate counsel face. American corporations are on the cutting edge in many areas of science, technology, research, and development. That makes them a target for hostile individuals, organizations, and governments. They attempt to profit from American ingenuity by infiltrating our computer systems, stealing our intellectual property, and evading our export controls. 2 weeks ago, the U.S. Attorney's Office here in the District of Columbia announced a guilty plea that follows this pattern. A foreign defendant and 17 co-conspirators allegedly targeted mid-size and large companies in the United States by impersonating executives in email communications with mid-level employees. The mid-level employees were tricked into believing that a corporate transaction was taking place. They transferred more than $1 million to foreign bank accounts controlled by the co-conspirators. Similar risks are posed by hackers who gain unlawful access to company computers. It can take only a few minutes for criminals to steal discoveries that took many years of work and many millions of dollars of investment for entrepreneurs to produce. Now, that sort of criminal activity is not just harmful to companies and their investors. It damages our economy and it threatens national security. Law enforcement agencies and prosecutors can achieve deterrence only indirectly after a crime has occurred. But a company with a robust compliance program can prevent crime or detect it early, reducing the need for law enforcement. Strong compliance programs are a company's first line of defense. Investing in compliance is essential to sustain a healthy marketplace. And we know that many American companies are very serious about implementing effective compliance programs. They want to do the right thing. They need our support to protect them from criminals who seek unfair advantages and who seek to damage American interests. Many corporations choose to work cooperatively with our prosecutors and investigators and with our civil enforcement attorneys in investigations that involve potential misconduct by corporate employees. A recent example relates to our efforts to combat opioid abuse. Last September, we settled a false claims case against a pharmaceutical company that manufactured a fentanyl-based opioid drug. The complaint alleged that the company paid kickbacks to doctors to induce them to prescribe the drug. The company agreed to pay more than $7.5 million to resolve the case. Now, that company had cooperated in a related prosecution of 2 pain doctors running a pill mill clinic in Mobile, Alabama. The doctors were sentenced to 20 years and 21 years in federal prison. The settlement with the corporation reflected its decision to accept responsibility and to help us to mitigate the harm. Things can go wrong in any organization. I can empathize. I reflect on that every day. My responsibility involves helping to manage an organization with 115,000 employees spread throughout the world. The actions of any individual employee can affect the reputation of the entire organization. When something does go wrong in a corporation, we should give the greatest consideration to companies that adopted serious compliance programs and timely reported the wrongful conduct to law enforcement. That frees up our agents and prosecutors to focus on people who commit the most serious crimes. When you assist the department, you help us to uphold the rule of law. That's good for America, and it is good for your client. Now, finally, before I conclude, I want to take a moment to tell you a true story that melds 2 of my top goals as Deputy Attorney General: to support the exceptional men and women in law enforcement around the country who protect and serve, and to combat the deadly opioid epidemic that contributed to a record number of American lives lost to drug overdoses last year. I mentioned that I met Jim and several of your colleagues at an event in Chicago last week. The Deputy Attorney General is protected by a security detail of United States Marshals, and 2 of them were in Chicago a few days before my speech to prepare for the visit. And one night, while they were returning to their hotel room from the gym, they came across a young woman who was unconscious and near death in a hallway outside the elevator. They didn't know it at the time, but she had overdosed on fentanyl, which is a synthetic opioid drug imported from China. One of the deputies started performing CPR, while the other deputy called for help. They kept that victim alive until the emergency medical technicians arrived. The team revived the victim with 2 doses of naloxone, which is a drug that reverses the effect of opioid drugs. The deputy who performed CPR on that unconscious stranger was checked at a hospital emergency room, and thankfully he received a clean bill of health. The Deputy U.S. Marshals, Tony Manson and Chris Carson, saved a life that night. They're heroes, but their experience is not unique. Every day throughout America, law enforcement officers put their own lives at risk in similar ways to protect and to serve. So please join me in a round of applause for the Deputy U.S. Marshals and for other current and former members of law enforcement. I want to thank you very much. I enjoyed spending the evening with you, and I hope you have a very productive conference. Have a good evening.
Jim, the Secretary of State questions.